con Mr. Charles Green. He's a board certified specialist in family law in the state of California. Thank you so much for the interview.
Yes.
And we want to ask you a couple of questions in regard of this divorce that you have the papers in front of you. What can you tell us so far from what you have seen? Is the divorce in process? Is it going to be a long process, or is it already finalized?
This divorce does not appear to be finalized yet. It was just started several months ago, and it does take at least 6 months for the divorce to be finalized. This divorce was started in May of 2018, so the earliest it could be completed in the state of California is 6 months from that date, and it's not yet 6 months. We're getting close. However, most people misunderstand that 6-month rule. You still have many tasks to do during that 6 months to complete your divorce. So you can't just file and serve the divorce and say 6 months is up. They have not completed many of the steps necessary to bring the divorce to finalization, to judgment.
What steps are they missing? Because, okay, we can start with Lupillo Rivera. He was the one who filed. Then Mayeli Alonso, she replied to that, to that filing, to that petition of divorce. She replied. In that reply that she did, she's asking for 5 things besides, is she asking for alimony, for child support, spousal support?
Yes, she is. She's asking for child support, spousal support. She's asking to be the primary parent for custody of the 2 children that the parties have. She's also asking to terminate his rights to get support from her, but she wants support from him. And it is a marriage of long duration. It's a marriage of 12 years that's stated here. And for marriages over 10 years in the state of California, the court retains jurisdiction for lifetime spousal support. Marriages of less than 10 years, the court could terminate that jurisdiction. But in this case, there would be lifetime jurisdiction for spousal support if she requests it and if she so desires. That would be an issue that there would be community property, which is property that is acquired during the marriage, generally. And then there is separate property. Separate property is property you had prior to the marriage, or property that could be traced back to some income source or property you had prior to the marriage. So she's asserting that all her property is separate property, all the property that she's identifying. That may not hold up in court, or maybe she can prove it. It's yet to be determined.
Because she had mentioned it in interviews that when things weren't going that well with the couple, she actually bought a house, and that now she lives in that house. Could that be that house that she lives in there, even if she bought it with her money when they were married, or that would have to be a different property?
Okay, that's a very good question, because generally, if you buy something during the marriage, it is presumed to be community property. When you walk into court for your divorce trial, you have the responsibility to prove that something is separate property. If you can't prove that it's separate property, then it is considered property of the marriage. So if she bought this house during the marriage, and even if the deed is in her name alone, it is still considered community property unless she can prove otherwise.
How could she prove otherwise? Because she bought it with her money, or is there another way to prove that,
She would have to prove that the source of the money to buy this house either came from an inheritance or money she earned before she married her current spouse.
Okay. You were mentioning before that she's trying to remove the part that she will have to support him.
Right.
Is that common in California? Because you were saying that she, by law, will have to be supported for life, right, because of she's been married for 12 years. But she's trying to remove that she's not going to support him.
Right, right. Even though she checked the box that says terminate terminate court's jurisdiction for her to support him. In this situation, in this marriage, the court would not do that. The only way that the court would terminate the rights of the husband in this case to receive support from the wife is by their agreement, because this is a long-term marriage, more than 10 years. So the court does not have the authority to terminate jurisdiction. However, if the case would have been a default, then that might have happened, but that would still be unusual because of the length of the marriage. So less than 10 years, jurisdiction for support could be terminated. More than 10 years, it can't be terminated.
And what happened in the case that they had a prenup?
Prenups are very interesting in the state of California as to support. As to support, the court will review the prenup at the time a party is asking for support. So if they got married 12 years ago, they probably did, if they did a prenup, it was more than 12 years ago.
Mm-hmm.
But the court's going to take a fresh look at the situation now. So even if she said, I give up my rights to support, that will not necessarily hold up in court now in a prenup. And that's something we tell our clients very carefully so they understand. So in California, you cannot, by prenup, terminate someone's rights to get support, because in this situation we can kind of figure out that she had 2 children, she had to take time out from her career to take care of these children, whatever work and skills she had became dated because she was helping the family. She was also helping her husband by keeping the home and so he could focus on his career. That's why support can't be terminated. So the court's going to take a fresh look at it now, and it is likely she will get support regardless of what a prenup says, because if the facts that we've put forth here are correct, the court should give her support.
And what happened in the case that she had become a very successful entrepreneur? She has a very successful business. He's also very successful.
Right.
In that case, when both of them are making money, would it go who is making more money to see who's going to support the other one?
Okay, so that's a very good question also. All right, support is calculated 2 different ways during a divorce. Prior to judgment, in other words, in the beginning of the case, the court does what's called temporary orders. When the court's doing temporary orders about spousal support, it uses a computer program to generally get an idea of what the support should be.
Things that she said that
Right.
they were, separate property.
Right.
Does he have to reply also to that, if he agrees to that or not?
Well, he would now, this could be considered a little aggressive to say all these things are separate property, unless they were traceable to assets from prior to the marriage. If she created different types of businesses or products during the marriage, that's marital property. And by stating that they're all separate property, entities and different cars and whatnot and things, by stating they're separate property and homes, if he has to incur expenses to prove that they're not separate property, that could lead at a time of trial to attorney fee shifting, where if he has to prove that she's taking positions that are incorrect, she might have to reimburse him for some of his attorney's fees to prove otherwise. So, but that would only be if they can't settle the case.
And according also to the court papers, he doesn't have a lawyer.
He does not have a lawyer at this time. No, it appears not. And someone with entertainment products, residuals, all types of revenue streams, if he has those, really needs a financially oriented, very experienced family law attorney for this type of agreement. A lot of people, sometimes people will try to save money by trying to keep attorneys out of it. But a skilled and responsible family law attorney can actually save you money. Checking one wrong box using the wrong words in a judgment or settlement could cost you a lot of money, and that's why having a skilled attorney to assist you can be a real positive in a complicated divorce.
Based on your experience, how long do you think that this case or a case like this will go for?
Well, they could still finish this divorce up fairly quickly within a few months if they do it in a open and friendly style, and they both have attorneys that will work in a collaborative way. If the attorneys, if they hire attorneys that are willing to share information freely and have an open and sincere discussion about what different assets are worth, different debts, and the parenting plan, which is a big part of a divorce, is what is the parenting plan going to be for the children? Okay, if they can agree on all these things, they could do their disclosures, write up a judgment, and then the only delay will be how long it takes the court system to process their judgment. So this could be resolved within a few months. If it is a litigated divorce, it would be at least a year, possibly 18 months or longer, because it does take time to set up a trial, to prepare for a trial, to find a courtroom that's going to be available for however long they think the trial will be.